So the court was looking at individuals who had ALS, people who at some point, when their suffering got to a certain point, they would not be able to take their own life. So the court reasoned that, well, we don't want those individuals to take their lives prematurely because assistance might not be available to them later on. So a really strict interpretation would say, okay, the court is referring to adult persons who have a terminal illness or a degenerative illness who will not be physically capable of taking their own life. So what the committee has recommended goes a fair bit beyond that particular scenario that was before the court. So they are talking about not restricting eligibility to terminal illness. So your illness does not have to be terminal. Your illness does not have to be physical. They have included psychiatric conditions. So this is something that was really, really troubling to me in committee, because they heard from the Canadian Psychiatric Association, Canadian Association for Mental Health, urging a lot of caution, particularly when it came to the question of mental illness or psychological suffering, to sort of the nature of these conditions and what that can mean for a person's ability to sort of look forward with hope, to be truly voluntary, to consent and have the capacity to make those kinds of decisions. So right off the top, these are sort of the top 3 recommendations, and they're going a fair bit beyond, I would argue, beyond what Carter has required. I think, we keep hearing Canadians want this. Canadians want physician-assisted death. I think that most Canadians think that what we're talking about is someone who is terminal or has a seriously degenerative condition who, has reached this point where they will be unable to take their own life. But as you can see, this conversation has gone so far beyond that. So how do we safeguard individuals who are vulnerable, individuals who have disabilities, individuals who have mental health conditions? Another recommendation is that initially, access only be allowed to persons over the age of 18 who meet the criteria. But they've written in there that it be a 2-stage process. So within 3 years, they recommend that access be extended to mature minors. So these would be children or teens who have been determined to have some capacity to make decisions regarding their health care. So that decision could include the ability to request their own death. The extension that the court gave expires on June 6th. So presumably the government is looking to have legislation passed at least, a good portion of the way by that date. It's a very, very tight time frame. So I would say absolutely people should be contacting their members of parliament. They should be contacting the justice minister and expressing their concerns about some of these issues. The other thing that I should highlight is there was a great deal of talk about conscience protection. So the court had said that no physician who objects should be forced to participate. And the committee agreed with that. But there was a lot of discussion about, should they be required to make a referral and how can we accommodate? Well, a lot of physicians feel that, or some physicians, I should say, feel that to make a referral is to participate in physician-assisted death. But the committee has recommended that at minimum, physicians should be required to make that referral. They have also required that any publicly funded institution should have to provide these services. So these are some really contentious kind of questions. The Canadian Medical Association, when they testified, had polled their membership, and they had found what percentage was willing to participate, what percentage weren't. And there was a small number who felt that even to have to make a referral was a violation of their conscience. But they said, it's not going to be a problem for access. It's a small number of physicians, and we absolutely need to respect and protect their right to not have to do that. And the same thing with institutions. Some of the language that was thrown around in committee was that bricks and mortars don't have conscience rights. And Cardinal Collins actually gave a really good response to that. He said, institutions are not bricks and mortar. They are people. It's made up of people. And so if you have an institution whose very ethos, if their mission statement is completely incompatible with taking life, that to require them to participate is a problem. So that's another issue that would be really good for the government to hear from Canadians about.